Okay, well, welcome to our Libertas lecture. The title is Maternal Sentencing and the Rights of the Child. I'm delighted to introduce our expert, Dr. Shona Minson. Most of you will know me. I'm Felicity Gerry QC, a member of Libertas Chambers. And of course, I've spoken out for many, many years about how the criminal justice system works in relation to women. I've defended mothers as accused persons, including appealing sentences for mothers whose children were taken into prison in the context of financial offending. I'm going to chat about some practical guides of what to do when you have a client who is a mother or indeed a primary carer after we've heard from Dr. Shona Minson. She is currently a British Academy Post-Doctoral Fellow at the Centre for Criminology at the University of Oxford, and author of the book Maternal Sentencing and the Rights of the Child. So without further ado, as they say, Shona, thank you so much for coming. We've got your slides on screen. We look forward to hearing about your research and all about your book. Thank you.
Thanks very much, Felicity. It's great to be here. I remember the first time I saw Felicity speaking at something about women in prison. I thought she was absolutely formidable and incredible, and so it's a really great honour to be presenting beside her tonight. So I'm just going to give you a bit of a sort of trip through why I did the research that I did, what I found, and what that means for us going forward. So I'm also going to hopefully be able to change. Have we got the next slide up?
Yes, we have. Great. Yes.
Great. So I came to this area having been a barrister doing family and criminal law. And of course, in the family courts, whenever the state separate a child from their parent because of abuse, harm or neglect to the child from the parent, the Children Act applies. And that means that the best interests of the child are the paramount consideration of the court. The child is represented by a guardian ad litem. They have legal representation, which is paid for by the state. And if they have to be separated from their parents, there is a provision of alternate caregivers for them. And those caregivers have been assessed, they are supported, and they are funded by the state. The contrast I discovered in the criminal courts was that when I began this research back in 2012, the situation was that the child might not even be mentioned in court proceedings where a parent was going to be sent to prison and a child was going to be left without their parent. So a situation very similar to the one faced by children in the family courts, but with no concern at all seemingly for the child. So I was bothered by this differentiated treatment. Just to give you a bit of background, if you're not familiar with the area, in terms of the numbers we're talking about, it's estimated that around 300,000 children in England and Wales experience parental imprisonment each year. And of those, about 17,000 experience maternal imprisonment. And my interest in maternal imprisonment has always been about primary carer imprisonment. So a lot of what I say might well apply to a primary carer who's not a mother. But you'll notice this slide is fairly blank because actually we know very little about this population of children. And that in itself is an issue. So to develop research questions, I started thinking about why there might be this differentiated treatment. What would possibly justify it? Three possible explanations seemed to occur to me. The first was that the state has actually excluded children whose parents are being sentenced from its duty of care. Secondly, children don't suffer any harm when their mother is imprisoned, and therefore there is no need to have concern about their welfare. And thirdly, it could be that judges aren't permitted to consider the impact on dependent children when they sentence a primary carer. And in terms of what was known when I began the research, we knew what happens to children when they're separated from their parents in the family court. And we also know that under the UN Convention on the Rights of the Child, Article 2, the state has a duty to protect children from discrimination or punishment that they suffer as a consequence of the status or activities of their parents. So the starting point is that the state should be making sure that children do not suffer because of their parents' criminal offending. What was unknown was whether judges were actually taking these children into account when they did sentence. And also we didn't know what was happening to children when their mums were in prison. So there was no evidence on that either. So I embarked on a fairly lengthy research project over several years, trying to examine each of these explanations in turn. So beginning with the first one, had the state actually excluded these children whose parents were being sentenced from its duty of care? And I won't go through each of these statutes, but we can trace the development of the state duty of care towards children from the Poor Law in 1601, where they said that if children were orphaned and therefore had no adult who had some responsibility for them, they were allowed to learn a trade. So there was seen as a need for children to be able to support themselves. And then if we go through the statutes from that time, the duty of care developed from, first of all, being an interest in children who had no families or children in work contexts. So then we go through the Education Act, Factory and Workshop Act, all about their working conditions. And then it moved to around the turn of the century, the Children Act 1908, to actually having concern for children who were in families. And it was about harms that might come to them from outside of the family, but then it moved to include harms that could attach to them from inside the family. And so the state essentially extended its reach right into families. And by the Children Act 2004 and the white paper, the Every Child Matters paper that was around the same time, and from the sort of big declarations of Cameron's government, the state had set a really high bar as to what they think they can concern themselves with children, to all the areas of life that the state has a right to intervene in and to become involved in and to try to make sure that children do well. And for the most part, that is a good thing. So that duty of care has extended. And then, sorry, I keep pressing the wrong button to move the slide forward. In terms of non-statutory framework, we've got the UN Convention on the Rights of the Child, 1989, which has the Article 2 right to non-discrimination, the Article 3 right for a child's best interest to be a primary consideration in any action concerning the child, the Article 12 right for a child to be heard in proceedings concerning them, and Article 20, the right to special protection and assistance for any child who is separated from their parents. And then we also have the Human Rights Act, 1998, which says Article 8, there is a right to family life, and Article 14, a right to enjoyment of rights without discrimination. Now, of course, we haven't incorporated the UN Convention on the Rights of the Child into our legal statutes in this country, but on countless occasions in Parliament, the government have reaffirmed, and successive governments have reaffirmed, that they believe that they are upholding it. So they tend to refer to the Children Act as being the indicator of that. But of course, the Children Act only applies to family proceedings. It doesn't go beyond that. But that said, we have had a lot of affirmation from government that they do intend children's rights to be upheld in this way. And you'll note that nowhere in this is there anything that excludes children whose parents are before the courts in criminal proceedings. These children are not excluded from that duty of care. So then moving on, and I do appreciate this is very much whistle stop. If you want more, it's all in the book in much greater detail. But if we go on to explanation 2, it seemed to me that potentially we didn't need to worry about these children if they don't suffer harm when their mothers are imprisoned. Now, a reviewer said that this was a straw man argument, and of course it was, but you've got to show what isn't happening in order to be able to show what is happening. What are the impacts of maternal imprisonment on children? Well, we know that a child with an imprisoned mother is likely to suffer more negative effects than a child with an imprisoned father. And the threshold at which their absence has an impact is lower than that of fathers. There isn't research that tells us why that is, but those effects have been found. And so even a very short sentence of imprisonment for a mother who's a primary carer can have long-lasting negative effects on a child. And we know that many of the women in prison in England and Wales are, I think more than 75% are sentenced to less than 6 months, which means they will serve no more than 3 months. But that is time enough for a woman to lose her home, her children, her benefits, her job, her future, and it can take years to get those things back, if ever. So unlike the situation where when a father goes to prison, usually children remain living with their mother in whatever home they have been in. But it's a very different scenario when it's a mother goes to prison. And how do I know this? Because I did research with children whose mothers were in prison at the time I did the interviews. And I also talked to caregivers who were looking after children whose mothers were in prison. And there were two sort of main areas that were affected. The first was the mother-child relationship, and the second was the impact of the imprisonment on the child's well-being and their future outcomes. So I've just got a list here, which is by no means exhaustive, but it's the main kind of areas that are touched upon. So a child would experience in most cases, well, in all cases, physical separation from their mothers who were imprisoned. And that for many meant a change of home and carers because women going to prison are often sole parents, sole carers for their children. And so the child has to move and live with somebody else in a different home. Because there is no state support, and because we know the demographic of women who go to prison is often at the lower end of the socioeconomic scale, the people who would take on the care of their children are often in the same situation, and with no support for that child coming into the household, they move into increased poverty. Can also affect any employment that a carer has had if they suddenly have to look after small children and can't afford nursery care or whatever. So poverty is a big thing that's seen. Children's education is disrupted. Again, unlike children who move into foster care, where the state has a duty, or schools have a duty to provide a child with a school place. So a child comes to me tonight in a foster care relationship, my local schools have to provide a school place for that child tomorrow morning. There is no such duty whenever a child's parent has gone into prison and they've had to move. So a lot of children in my research spent, in some occasions, months out of education. The worst I think I came across was a family with 5 boys, 4 of whom were school age, 2 were in the final year of primary school, and they were out of school for 3 months because the local schools near their grandma had no places for them. Even if a child is attending school, they often find it very hard to concentrate, and they become socially isolated because of stigma and shame. Now, quite often the children haven't experienced something directly, but they are so conscious of what they might experience if they tell anybody that they begin to self-isolate so as to not risk that. The press don't help at all, because if something's been reported in the press and a story has gone out that names a person and perhaps their address, and as we all know, often the media does not give an entirely accurate representation of what has happened. But even if they do, for a child to walk into school the next day knowing that everybody knows is a really problematic thing for them. There are changes in the mother-child relationship. Their relationship has to fit into any time that the prison allows for it. I've said difficulties in visits. These often take place during the school and working day. And so not only does a child have to potentially miss school, but they need an adult who has got the finance to bring them to a visit, who can also come during working hours. Children, therefore, again, recognise that their mother cannot meet their needs as she once did. And so they try to protect her a bit because they're so upset about what's happening to her. She tries to protect them, and the relationship becomes more distant and difficult. Children within my research sample, almost all were displaying very, very similar behaviours, changed behaviours, which were some sort of internalising of this confounding grief they were experiencing. And I identified a grief response, and other people have talked about ambiguous loss for these children. I called it confounding grief because there were 2 elements to it that I thought were confounding. First of all, the grief was there because the child was sad that their mother had gone to prison, and that sort of permeated every aspect of their life. But their life had been confounded, their expectations had been confounded, everything had changed for them. The other thing that was confounding was society did not know how to respond to a child with mother in prison. And so unlike a child who's experiencing separation of their parents, or divorce or bereavement, or even being posted overseas, where we all know how to give those children extra attention, a bit of extra concern, and everybody rallies round, the same does not happen for children when their mother goes to prison, because there is this underlying notion of, well, she must have been a bad mother, and so now she's gone and they're probably better off. So the children were struggling on many accounts. In terms of longer term impacts, there is a lot of research that talks about the experience of maternal imprisonment as a child as being a turning point, an event that alters the trajectory of somebody's life. These children, by the time they grow to adulthood, are less likely to be in education, training or employment, more likely to have mental health and addiction problems, are likely to earn less than their counterparts aged 30, and are more likely to die before the age of 65 than their peers. And that applies whether mother or father has been in prison, but it is elevated for those who've had a mother in prison when they were a child. So these are long-term, lifelong effects. In terms of intergenerational offending, it's something I don't ever tend to lead with because I think labelling is really problematic. But there was a paper came out last week that showed that for girls whose mothers have been criminalised since the child's birth, those girls are more likely to be in some sort of criminal justice contact by the time they're age 12. And so I think all of this, the disruption that happens, can feed into other disruptions in children's lives. What about the impact on caregivers? We've already alluded to employment being problematic, household finances, their housing, their relationships, their health. And so for somebody to take on the care of a child whose mother in prison, it comes at really high personal cost to them. And I think that is often forgotten and often absolutely unacknowledged by sentencers. So explanation 1, turns out the state has not excluded these children. Explanation 2, these children suffer harm potentially across every aspect of their lives and for the rest of their lives. So it's not that either. Could it be that the reason we don't think about these children is judges are not permitted to consider the impact on dependent children when sentencing a primary carer? There are a lot of principles that have been established by case law going back to 2001, when Lord Phillips, in the case of P&Q, said that the sentencing engages the Article 8 right to respect for family life of both parent and child. Any interference by the state with this right must be in response to a pressing social need, in pursuit of a legitimate aim, and in proportion to that aim. The more serious the intervention, the more compelling the justification must be. The act of separating a mother from a very young child is very serious. I interviewed Lord Phillips in about 2015 about this case, and he believed that everybody had been following this judgment ever since and was quite surprised to discover they had not. But that's 2 decades ago that judgment happened. So this is not a new principle that the Court of Appeal have come to. This is quite long-standing, but very much ignored. In the case of Bishop in 2011, Court of Appeal found that it was on the court the responsibility to find out about the child and to know what would be an appropriate sentence given the impact it would have on them. Case of ZH Tanzania, which was Lady Hale, the welfare of the child should be at the forefront of the judge's mind when looking at separation. And then the case of Petherick, which tends to be the only one that people know about if they know of any of these, although I do hope that's changing. They found there was no standard or normative adjustment for children, but they are a distinct consideration to which full weight must be given. That on a threshold case with custodial, non-custodial, the impact on a child could tip the scales and make a proportionate sentence disproportionate, which I think is a really important statement. And in Modwadia, they said it could be appropriate to suspend a sentence where it is a primary carer or parent. So that's the case law. In terms of guidelines, again, since 2011, in every guideline, it is said as a factor in mitigation that the court can consider that someone is the sole or primary carer for dependent relatives. That got strengthened up a bit in the imposition of community and custodial sentences guideline in 2017, which makes the point about cusp sentences and that it can make a custodial sentence disproportionate to achieving the aims of sentencing. So alongside all of that, I then did 2 things in terms of research with judiciary. I did semi-structured interviews with Crown Court judges and recorders to find out what they were actually doing. And I did a transcript analysis of 43 Court of Appeal sentencing appeals by mothers. So very briefly, in 27 of the sentencing appeals, the appeal was allowed to some degree. And in 23 of those cases, the appeal court said that the lower court had given insufficient weight to child dependence. So again, we're seeing that at the higher level, at the Court of Appeal, they they really understand that taking the impact on children into account at sentence is the appropriate and right thing to do, but the lower courts were not doing that. In the interviews with Crown Court judges, I've just pulled out 4 key findings. The first was that judges were not taking a consistent view on the relevance of dependence as a factor in mitigation. And of course, there is a list of factors in mitigation, and judges are not told how they should consider those. I did a weighting exercise with judges where I said, if you could give this factor, mitigating factor, between a 1 and a 10 in terms of how important you think it is. So of course, wholly artificial exercise, and they didn't really like it, and some refused to do it. But for those that did do that exercise, and it included things like remorse, age, illness, other sort of personal circumstances, factors that are all in the list, solo primary carer for dependent relatives was the only factor that was given both a 1 and a 10 by the judges. So in all the other factors, there was some clustering. You know, they might all give remorse a 7 or an 8, or they might all give age a 2 or a 3, whatever it was. But this one got 1s and 10s and everything in between. So there's absolutely no consistency. Their understanding of the guidelines and case law was, to put it very politely, limited and at times incorrect. So I had a range of opinions on that as well, and they were opinions that some thought there were no guidelines, there was no case law, and it was up to them to decide what they thought on the day. There were others who thought there were guidelines and case law that said they should never consider children when they were sentencing a parent. There were others that said, in fact, it was contrary to justice to consider child dependence. So about half of them thought there was maybe case law or a guideline that referred to it. Only 1 mentioned the best interest of the child, and only 1 mentioned Petherick, and none of them knew that it was the court's responsibility to have that information before they sentenced. There were common misconceptions that hindered a judge's willingness to make appropriate inquiries about children and to properly understand how their mother's sentence would affect them. Those ranged from things about the age of a child. So some judges thought that only babies were affected, some thought only teenagers were affected. So they all had quite clear views, but fairly uninformed views about what would matter. There were views about sociodemographic status. So there's a very long quote in the book, which I don't have time to read out here, but where a judge essentially said, if it's a middle-class family, I try to keep them together. But if they're a bit poor, and I don't think the children have got great prospects anyway, so I'm much less bothered. That's a paraphrase, but that is essentially what was being said. They thought that a criminality for many of them equated with bad parenting, which of course it does not. And often crimes might be financial in nature or poverty driven, and there is nothing of concern in the parenting. And there is certainly, for most children, their primary attachment will be to their primary carer. And in family law, we always look for, it's about good enough parenting is what's looked for. But the courts were not looking for good enough parenting. They were just making assumptions about bad mothers. And then judges weren't requesting pre-sentence reports as a matter of course. It turned out that judges who had some sort of background in family law, so they maybe had been in a family barrister themselves and had knowledge about care proceedings, what would happen, they understood how significant it was to separate a mother and child. And they therefore would ask for more information and would try to get as much as they could. Whereas those who didn't think about it beyond knowing that they'd be physically separated didn't ask for more information. So if a woman ended up in front of a judge who already knew nothing, as it were, it was a sort of double jeopardy, because that judge was very unlikely to go looking for more information because they didn't realise what they didn't know. So the findings then from the research were that judicial awareness of guidelines and case law was inconsistent. They didn't understand the impact of maternal imprisonment on children. So they were allowed to consider it, but they didn't know how to, or they didn't know that they should. Children do suffer harm when their primary care is imprisoned, and adults were also taking on the care of those children and suffering harm in addition, which then of course feeds back to the child, because having a supportive caregiver is a really key protective relationship. So, was there discriminatory treatment against this group of children? What I found was that yes, procedurally and in practice, there is differentiated treatment of children being separated from primary carers in the criminal courts under the Human Rights Act and under those articles of the UN CRC. And the state was failing in its duty to protect children from discrimination that they were facing because of the status and activities of their parents. I told you I tested my 3 possible explanations. None of those turned out to be the reason. So what might some alternative explanations be? I think there's an issue about construction of children in the courts, because our family courts and our criminal courts and other courts are all very separated from each other. We view children in the family courts as very much needing care and protection and welfare. In the criminal courts, child is more likely to be there in the youth court as a defendant, or if they're there, the victim or witness, which is a different thing. And so there was a sort of labelling and secondary stigmatisation of these children as aligning them with their parent, who was the defendant. And there was a lot of sort of discussion and talk about, you know, they're going to be a bit like their parent. We're just, you know, that's the trajectory we're following. And so they matter less. We don't need to pay them quite as much attention. And then I think there's a big issue about the invisibility of women in the criminal justice system generally, and misunderstood notions by sentencers of what gender equality and fairness looks like. So, you know, the number of times I heard, but if I consider the impact on their dependents, then that's unfair to a man who doesn't have any. And that's ignoring the fact that actually every case is sentenced on the facts of the person in front of the court and their circumstances. And in fact, if the Court of Appeal and the guidelines say you should be considering it, you should be considering it. So what does this mean for punishment and for sentencing? Well, in terms of punishment, my own view is that we need a communitarian theory and practice of punishment. People do not exist in isolation. And so our theories and practices of punishment need to include those who are not the direct subjects of the punishment. I tried to show and argue through my research that actually the harms that children suffer in these situations do have their roots and causes in the imprisonment of the mother. And I used 2 concepts, secondary prisonization and secondary stigmatization, to try to show this, because the argument is often made that actually the harms to children have nothing to do with the imprisonment. It's because of the general chaotic nature of their lives or other structural factors. But I think actually we can draw some quite clear lines between the imprisonment of mothers and the harms that are caused to their children. What about sentencing? So I felt that the treatment of children had been an institutional and an institutionalized blind spot. Sentencers just didn't see it. And what was heartening in a way was when I brought it to their attention, they were quite quick to realize this was a problem and that differentiated treatment was not all right. So I made a series of films for judiciary, advocates, probation, called Safeguarding Children When Sentencing Mothers, and for women themselves facing sentencing, to set out these are the parameters of the guidelines and the case law, and also these are the impacts of children. There was a sentencing guideline in October 2019, which they Sentencing Council consulted on, and we rallied a lot of people together to respond to that, and they actually took on board what was being said, and I'll just go through that in a minute. And I'm not sure whether that has resulted in changes in practice or not. What this it's called an expanded explanation for solo primary care of dependent relatives. So we are still reliant on a judge deciding that solo primary carer is a relevant factor in mitigation. But if they have decided that, then this guideline sets out what they should then be thinking. So they should be thinking about proportionality. They should be thinking about impact of sentence length. It's also relevant if it's a community sentence they're looking at, the effect on dependents. They need to think it's specified. They must be thinking about the health of a pregnant woman and the health of her unborn child, which is very pertinent and really important. The court has to get the information, should consider adjourning if proper arrangements haven't been made for children, and should ask for a pre-sentence report. And this is, you know, this is very positive. All that's there is really important and should be happening in every case. Joint Committee on Human Rights, I went to them with my research and said, how about you hold an inquiry, because I think there's a breach of children's rights going on here, and that happened in 2019, which was great. they made recommendations about data collection, sentencing, support for children during imprisonment, and pregnancy and postnatal care. Disappointingly, the government have not responded yet to those recommendations with any changes, but it did at least draw a line in the sand and say, yes, these rights are being breached. And the other thing it has done, which is, in my view, marvellous, is that the Human Rights Committee have really got onto this topic. And so in the Police Crime Sentencing in Courts Bill, there are a number of amendments that are being put forward and are being debated again. Well, the report stage in the Lords, I think next week or the week after, where actually what we're trying to do now is to get something in statute so that it's not left to judicial discretion as to whether they choose to consider sole or primary carer as a mitigating factor. But it is there in the statute saying in every case where you have a primary carer, you must make these inquiries, you must get a pre-sentence report, you must make an assumption that actually a non-custodial sentence will be better for the child or the unborn baby, and also something about data collection. And these are tremendously important. Last time they were in the Lords, Lord Wolfson's response was, well, already that's in the sentencing guidelines and they have to do it anyway. And he's missing the point that they're referred to, these things, but nobody has to do it. It is not mandated. And I would be pretty certain that if I was to do the research I did 4 years ago now, I would still find inconsistency across the judiciary and magistracy in terms of how they are sentencing. And just to flag up, if any of you are lawyers or magistrates or judges, there is a questionnaire at the moment where people can give evidence on what is happening in hearings when primary carers are being considered, just to try to see what the real state of play is, rather than anecdotal references being made in the Lords to, well, you know, somebody saying, well, when I was a lawyer, I never did that, or I did do that. So we'd like to get beyond that. So just to finish off and keep asking the questions, there is so much more to be done here. I mean, I feel Felicity and I have been going at this for at least 10 years. And it's moving, but it's got further to go. So we'll ask in all these situations, what rights does the child have? Are they being infringed by what's happening to their parents? Does the state have a duty of care? And is the state fulfilling that duty of care? And I think this is relevant across other courts and tribunals: immigration, asylum, deportation, mental health, detention, punishment in the armed forces. And there's also a really interesting, but there's no time to go into, interplay between the criminal and the family courts and the assumptions made about criminally involved families whenever they're in the family courts. But I will leave it at that. Thank you very much.
Fantastic, Shona. Thank you so much. And of course, as ever, shocking. The shocking statistic of 300,000 children at the beginning is just frightening, really, how many children are affected by this. And obviously very timely to hear from you when this debate is going to happen next week. And we are going to be thinking about whether or not the Parliament will be correct enough to impose a statutory duty. Before I ask you, and before we go over to our Q&A, as always in our Libertas lectures, I'm just going to chat about some experiences that I've had in these types of cases to try and pass on some sort of skills-based, I suppose, suggestions that have come about during the course of my practice. So not research, really anecdotal, as ever, as a barrister, always all about me. That's what we do. But I hope this is helpful for those of you listening in. Why have I taken an interest in this topic? Because obviously you don't get women in court quite so often as you get men. They're usually between about 5 or 10% of the prison estate, if you like. Far fewer female clients. And actually, I think that's the starting point. I think we should always think that it's exceptional to have a woman before the court. If we're surprised, which we always are, if it's unusual to have a woman as a client, then it's exceptional. And if we can approach these exercises either not prosecuting women at all or if they are prosecuted, being very careful about what charges. And then if we reach the point of sentence, thinking about the duty of primary carers to their children, I think is absolutely vital. So why me? Well, before I ever had my own children, I went before a family judge who was sitting in a criminal court to try and sort of do a dual case. My case was in front of the judge in relation to the criminal matter and the family matter, and we were trying to do it all in one go. It was all a bit peculiar, and I won't bore you with all the details, but the mother turned up with the baby. There was no one to have the baby. It was sort of the best moment and the worst moment in the case. What are you going to do? And there was no one to hold the baby while we were at court. So I said to the judge, well, we can't come in, we've got the baby. And he said, oh, I like a baby, bring the baby in. And this adorable baby, who'd been very well behaved outside court, came into court and was quite noisy and chatty, not crying, but just very noisy and chatty. And the judge, of course, couldn't focus at all, wasn't used to working with babies chattering away, as perhaps many of us are. And just said, oh, Miss Gerry, you know, take the baby outside. You can have whatever orders you want. Just write out my orders for me. So in the family court, I wrote out the orders and I got the orders. And then back in the criminal proceedings, we were successful. And I thought that was a really interesting day. I think I was only 3 or 4 years cool. And the idea that you sort of had to waive a baby as a judge to get a different outcome struck me as really interesting. Because we don't waive the baby, do we? We might say, oh, and he's a father of 2 children, or she has 5 children, but those children are not there. And then I did another case not long afterwards where the children had written letters, dear judge, please don't send my mother to prison. And in the robing room, the suggestion was, well, you can't put those in front of the judge. They're not proper evidence. And I thought, well, why not? Why not give these children a voice? And the judge took it very well and was really interested and gave sentencing remarks that, of course, were not written down, that he hoped would be passed on to the children as to what the outcome was. And then there was another occasion where I came in on maternity leave for a sentence for a woman, because I felt so strongly that the court really needed to understand the situation of this mother and not to send her to prison. And I shouldn't have been coming to court at all. And there was no one to look after my baby that day. So bless Dot, my clerk at the time, who held the baby for me while I went into court and dealt with this sentence. So look, those personal experiences have really influenced what I've done over 26 years to try and bring attention to the poor treatment of mothers, particularly women, in the criminal justice system. And I've watched cases go so badly. And another one that sticks in my mind was a woman who was being dealt with, if you like, for contempt. Now, she hadn't turned up to give evidence in a case, and the judge insisted that she was arrested and hauled before the Crown Court, and we had a full hearing in which there was this examination of why she hadn't turned up, and the police officer gave evidence, and when he'd gone to the house, she chatted away to him. So she'd given quite a lot away about why she wasn't going to court the next day, because she'd got children to look after and it was all too hard. And the judge took the view that this was a deliberate refusal to come to court that had been planned the day before. And we got through the whole hearing, and eventually he fined her £20 that he thought was him being merciful. And she clearly didn't have 2 coins to rub together, and £20 was going to have a serious effect on her and the children. So you watch these cases where mothers are being dealt with, and there are these terrific stereotypes around the bad mother that you see all the time. And the higher up the scale you get of the charges, the more you get this language about you should have known better, or and you're a mother, instead of thinking, oh, you're a mother, how am I going to deal with this case? And you particularly see it in cases involving what we used to call joint enterprise, that you'll see mothers being charged with the most serious offences because the prosecution want her interviewing to try and convict the male partner for whatever he's done. So no real rationalisation of what you're doing, putting this mother in court on trial for the most serious offences because she said something that might be useful to prosecute somebody else, and therefore putting her family and children at risk of the sort of terrible harms that we've heard from Shona today. So I think all these things need thinking about. If you are representing a mother, you need to think about how the system does not adjust itself for women. And certainly understanding the vulnerabilities of women in prison is really important. I lectured judges and said, who's read the Tokyo rules and the Bangkok rules? And I think I got one hand. It does seem they simply don't read around the issue. And if the judges are not reading around the issue, there's then a real worry that the advocates, as Shona has explained, are not reading around the issue and not providing those judges with the sort of material that we've heard about. More recently, I did 2 appeals in Australia, which involved mothers who carried out financial offending, quite a lot of money. Most, if not all, had been paid back, both of whom had babies that were taken into prison with them. And that, I can't see the point. What on earth is the point of putting a baby into prison or a young child into prison with their mother for financial offending when someone has paid or nearly paid all the money back? It's often financial offending in order to maintain a decent lifestyle for the child. So it's a loving mother who has committed that type of offence. In at least one of those situations, there was a background of domestic violence. It struck me that this was an absolutely pointless exercise. The problem was none of this had been argued in the lower courts. So me trying to run best interests of the child, exceptional hardship, all of those issues around the effect on the children, really fell on relatively deaf ears before the appeal courts, who said, well, look, none of this was said in the lower court. And I think that's the thing I want to pass on the most. If you're going to reach the Petherick test, at the very least, you're going to show that your client is on the cusp, or the parenting might make the difference, might make it a proportionate sentence disproportionate if the parent is sent to prison. If you're going to try and argue that, you need as much material before the court to put the court on that balance. Actually, what we should all be arguing for is those non-custodial penalties. Parents should be with their children, and community penalties for parents are really draconian. They're really, really hard, but they might also come with the sort of support that that parent might need. So there's a real value for alternative sentencing for primary carers that I genuinely don't think is recognised by the Lords in the debate that's going on next week. I don't think the judges get it. Shona was very polite. I think Lord Wolfe actually said, judges get this, and they plainly don't from Shona's research. And I think she's right. If we did that survey again, we'd get very similar results. But more importantly, that question that Shona posed, that you've got to get to the judge considering the sole or primary carer issue before you can get to that guideline, is a very difficult one to persuade judges to get there, depending on what case is before them. And especially when they've had maybe 30 years in practice, not dealing with these things and not being in the family court and not having to consider guidelines of this type. I listened to a career judge the other day, a female judge from Afghanistan, and she talked about all the work that she had to do to be a judge as a career judge, and all the human rights frameworks that there are in Afghanistan that have to be applied in relation to being a member of the judiciary in Afghanistan. Now, it was eye-openingly fabulous. And it sounded so different, that the expectation was that judges had to engage in the research and engage in the latest human rights guidance and really understand how the laws work in relation to child rights, for example, or any human rights the judge was discussing on that occasion. I think there's a real argument for having a career judiciary with younger people and a more diverse judiciary to really get these issues. And an example I gave when we were having a lecture from Dr. Emma Milne a month ago was in a case where I was dealing with a sentence for a child for manslaughter, where there is a statutory duty to consider the sentence for a child. The prosecution didn't produce that material at all. They just gave the judge the manslaughter guideline, which actually doesn't apply to children. So it's a really good example of how prosecutors are not trained in this material. I think the other skill to have is always to write some written submissions on a sentence like this, because it might well trigger the prosecution to do the same. I actually think judges should ask for written submissions on sentence, and I genuinely think judges should give written reasons with authorities, and that's the way to embed this into judicial practice. And it would be embedded well if the proposals in the new bill are followed, because it would create that requirement for judges to do that without losing their discretion in how to build the sentence for the individual. So I think it's really important that our skills have to be the identification of the issues for the whole family if you have a primary carer before the court, the production of all the relevant cases and research with written submissions to the judges in advance of sentence, giving them plenty of time to think about it. It's a bit of a joke when I do it with judges. I try and make a bit of a joke, say, oh, you know, as usual, I've given you a plethora of information, and the judges laugh at me, and I'll take that on the chin because I know they've got to read it, and I'm going to make them read it. Forgive me if I take a little while just to take you through these paragraphs. So I think you have to be brave. I think you have to make time. I appreciate everybody's under pressure, but ultimately the pressure that we're under pales into insignificance when we think that if we don't change the way in which we sentence, particularly mothers, primary carers, but particularly mothers, what we've heard from Shona today is we shorten the lives of those people. And if nothing else, if that's not the impetus to say, get the reports, get the references, get as much information as you can as to why that person should be sentenced differently because they are a primary carer, and particularly if they're a mother. I hope that this is a useful, you can hear I've got a bit of a cold today. It's not COVID-19, but I hope this is a useful, slightly rambling set of information that I've put together over the years to say we do need to approach this differently. We must recognise that when we're representing a primary carer for whatever offence, and particularly if it's a mother, it is an exceptional exercise. Get the prosecution, if you're defending, to engage in that exceptional exercise and place before the judge as much material as you possibly can. Frankly, they should all be reading Shona's book. All right, so that's enough of me rattling on. Shona, a few questions. What can we do to turn those statistics, the 300,000 estimated figures of children affected by sentencing, what can we do to turn those into factual figures? How can we collate that?
I think that it could be done if we had data collected at various points. So at the moment, there's no data collected at arrest, there's no data collected at court, and there's no data collected at imprisonment. And if it is, it's kept locally and not shared nationally. The Human Rights Committee asked for this data collection, so that was 2 years ago now. And what keeps coming back from the MOJ is we're looking at it, it's very difficult. But I think it could be done. I think what is really, when you say what can we do, I think there is a huge sort of hearts and minds public battle on this one, because until our politicians see this as something that actually matters to the general public, it's very hard to persuade them to give it, as you said, the time that this needs and to give it any importance. And I think most people are very surprised that we know as little as we do, and that the harms to children are as great as they are. So I think there's something about talking about it, knowing about it, sharing that with other people, starting a kind of a quiet or noisy revolution, but where we just keep mentioning this and we don't let it go quiet.
Mm. Yeah, it's really surprising, isn't it, that you can imagine the removal either of yourself from your own mother or your child from you, that you can, the feeling that you would have even just thinking about that, you know, and you don't need to have children yourself to know that feeling, how you would have felt being removed from your primary carer. And whilst I appreciate there are some bad primary carers and we do have cases of cruelty and abuse, of course we do, the vast majority of people are very good parents, and we mustn't equate criminality with parenting.
And what's really interesting, Felicity, is that there is a child cruelty guideline from 2019, which has a separate step in it that says the court must consider the parental responsibility of the defendant. And that's when the victim in the case is their own child. So the only time that the courts are specifically told they must think about parental relationship and whether putting this person in prison would harm their child is when they've in fact harmed their child already. And that just seems to me to be very backwards.
Well, is that designed to, does that fall into that narrative of bad mother, bad parent? Is that what, do you know how that came to be in there?
I don't know how it came to be. I think it's probably about victims. They've said the child is a victim, therefore we elevate the child in this circumstance, and therefore their relationship with their parent matters more because they have been a victim. So it's again this thing of discriminating against children based on, you know, differences that are nothing to do with them and should not be making difference in how they're treated by the courts.
And there's this very simple statement, isn't there, in the Convention on the Rights of the Child, that children should not be, I'm going to use affected, it's the wrong word, I know, but by the acts of their parents.
Yeah,
I can't remember the exact phrase now, but it seems so obvious, and yet we don't see it happening in the courts. Now, of course, we can hear your research, but how much do you think that falls into these narratives, these myths and stereotypes about bad mothers? You've talked a little bit about the media not helping. Is it worse than that? Is it because we have programs like Orange is the New Black that gives these terrible pictures of women in certain circumstances? Although, to be fair, they did try and deal with motherhood in that program, so I perhaps shouldn't pick that one in particular. Is it because we have these narratives about going into prison and meeting these terrible women and dehumanizing women at the point of sentence?
I think there's a lot of that. I think there's about people not understanding who in fact is in our prisons. So whenever you look at the number of women who are in prison for sentences of even less than 12 weeks, even shorter times than that, and you know that if someone's only in prison for a few weeks, they have not committed a serious or dangerous offence. And therefore you question why anybody has given them a prison sentence. That's a whole different talk. But I think when you start to unpick with the public, well, why do you think women are in prison? Do you think women are in prison for non-payment of, I mean, they weren't even supposed to be in prison for non-payment of council tax, but there were a number of women in prison for that, despite it not being an imprisonable offence. There are women in prison for non-payment of TV licenses. There are women in prison for all kinds of things that I think the person in the street would find slightly unbelievable. And so there is a problem with that. But I think the media, they like to polarize. They like to make, you know, if I'm watching, they want me to feel good, like I'm a good person, and these are other people who are bad people, and set those divisions. So there was an episode of Loose Women a few years ago when the Human Rights Committee report came out, and it was terrible. There was Paula Harriott from the Prison Reform Trust went on with Jenny Earle, and rather than being allowed to talk about the issues, all it turned into was talking about, well, you know, why were you in prison? What did you do? It all turns into what about the offence? And I think that's why we have to talk about children separately, because this isn't about the mother's right or wrongdoing. This is about the children's rights within that situation. So in the same way with children, where there's been abuse or harm or neglect, we look at the children's needs, and we're not saying, well, because this parent has done this, we will therefore write off this child as well. And so I think there's a real demonization and a salaciousness in wanting to have sort of nasty images, and also to make ourselves feel like we're good people.
And all the more reason,
people.
yeah, all the more reason then to have a statutory duty to ensure that that's clear, not just to the judiciary or the lawyers carrying out the cases, but to the general public, that we take our duty to children seriously. If we've signed up to the best interests of the child, we can't ignore the children who are affected by their parents' sentencing. Look, I could rattle on about this for hours, and I find it shocking that what you're talking about is exactly how it was when I started a quarter of a century ago. And I'm not confident that it has changed since those 2019 guidelines, not least because of COVID-19. I think we've had this hiatus in implementation. And I think people are under pressure who are representing people in cases. And it's fantastic to have sessions like this to remind everybody of what you need to do if you've got an exceptional client. Now, I'm just wondering if there's any questions from the audience. Would anyone like to put their hand up or speak to us or give us some examples? Or just say how you might change your practice. What would you do differently now you've heard what we've had to say? How much more can you do for your clients? What is it that you need to talk about what's in the best interests of the child? I'm not convinced it's just letters from the children. I think it's quite interesting when you think about character references. When you come to a sentence, you might think, well, I'll get some character references for the mother. But actually what you might want to do is have those character referees also talk about what's going to happen to the children. How are the children going to be affected? The people who know that family best. And getting all the family members to say, look, if this woman goes to prison, or if this primary carer goes to prison, this is going to be the effect. I mean, the example that you gave us, Shona, about if they don't go into foster care, they might not have a school place if they go to grandma. I must say, I didn't know that. And I think I know all this stuff. So if I think I know, and I didn't know that one, and I feel I should have done, but and I like to think I would have known it at the point that I was dealing with a sentence for a primary carer, then if I don't know it, and as you say, we've been talking about this for a very long time, then that's the sort of thing that I can be 100% positive the judges don't know. So we've got a question here from somebody in our audience. Do you find the responses differ between men and women judges in regards to their knowledge on children's rights? Shona, can we say from your research?
No, there were I couldn't say as many women, but actually, I tried to match the percentages of women across the judiciary to my research samples, so that, and there are not as many women in the sitting as judges as there are men, so there were more men in the sample. But it certainly was not a gendered thing in terms of, if you think, oh, women judges will be more aware of children. It was very much those who had some experience of family law were the ones who thought about it. Those who had not got experience of family law did not think about it.
Yeah, and I think there's a real worry that, first of all, we have a very privileged profession. So if we don't have a career judiciary, what you tend to get is very senior barristers becoming judges, certainly in the Crown Court, and they're often very privileged people. And you might find that what you get is men or women are holding people from disadvantaged backgrounds at a much higher standard. And matching, as I did, matching your own experience of having children with that person's experience of having children, for which there is no match. It's never has been as hard for you as it has been for somebody facing a criminal court. You do have to put your own knowledge of parenting to one side. And
I can give you a little quick example of that, where I was asking if a judge had ever thought about carers, what it's like for somebody to take on the care of a child in these situations. Which is that they came on their niece when their sister had died, and they said, well, of course you do it and you don't think twice about it. But I suspect they had room in their house and they had a big judicial salary and all those things, and that's a completely different situation from grandparents I spoke to who actually were saying some years after they'd taken on the children, if we'd known what this would cost it, we might have said put them up for adoption because it's been more than we can manage. So as you say, Felicity, people project what their own experience would be, and it's not going to be the
same. Yes, that you have to hold yourself in, don't you? At times like that, certainly at the bar, you have to think, no, it's not about me. We've got another question. Do we think there's a difference depending on the seriousness of the offence?
Yes. So there, in the research I did, there were a lot of judges who said, well, obviously, if it's going to be custodial, then I don't even think about the children. They are irrelevant. Once I've decided they're going to prison, then it's neither here nor there. Now, in fact, the 2019 guideline says it is always relevant. There is no case where you cannot think about that. And I was asked to prepare some research information for a case that was in the Court of Appeal maybe a year or so ago, where a mother had been given 12 years. And in fact, with evidence on what the impact would be on her children properly before the Court of Appeal, having experienced her in prison for a time by the time that appeal came up, and it had been argued at the lower courts, they were able to give more detail. It was reduced down to 7 years. So I think although judges may want to say, oh, well, it doesn't matter because I've decided this is terribly serious and they're going to prison, it still matters for length of sentence.
Yeah, I think that's right. You know, some prospect that you might get your mum back. Must be fantastic for a child. You know, we've got to go through this until you're 11, but then mummy will be back. You know, those sorts of things can be really reassuring for children. It's not going to be forever. And we've got quite a complicated question here, which I suppose raises the isn't this a get out of jail free card, which is the question that you're asked the most often. And I think I'm going to just preface that with, of course not. Sometimes it's a shorter sentence. Sometimes if it's a community sentence, that's a way of providing significant punishment for a parent. But the question is this: one view is that people with children will then get a free ticket to commit crime and get away with it without going to prison. Is there a chance that gangs then start targeting mothers like they target children in county lines set up? I think that's a whole research project in itself. So, Shona, I think the targeting of vulnerable mothers is something that we can take into account. I think that would become probably some form of modern slavery defence. And we have really protective systems that are set up for people who are exploited in county line setups. But Shona, have we got some research that helps to answer that question? Because I think the get out of jail free card is so problematic, it's probably worth thinking about that.
Yeah, it is. And I think it's interesting that in the firearms offences, so you've got a mandatory 5-year sentence for somebody in possession of firearms. And I wrote an article about this maybe 5 years ago, because there were a lot of young mothers were ending up in prison for long periods of time because a boyfriend or somebody, some male, had hidden a gun in their baby's room or whatever it was. And then the courts were saying, I cannot give this person a lenient sentence because if I do, then people will just keep targeting vulnerable women because they will think they don't get a prison sentence. Now, to me, that did not make sense, because I do not think that the men who were hiding the guns were terribly concerned. You know, they weren't going to go, oh gosh, right, she went to prison, I'm not going to do that again to somebody else. So I don't think that's the way the world works. I think yes, I think yes, they may get targeted. I think they get targeted anyway, even whenever there is a prison sentence is what's going to happen. So I think we have to sort of set that argument aside and say vulnerable women are going to be targeted by exploitative men to commit crimes, regardless of what sentence they face. And it is for the court to ensure that the appropriate sentence is given, bearing in mind they have children or whatever it happens to be. So yes, I think that's an issue, but I don't think that's a reason to not properly sentence.
Well, all the more reason to have a structural framework that provides the sort of protection for mother and child from those exploitative people. That's how I would answer that. I think that's how our criminal justice system should be framed, to ensure that we target those people who are exploitative and not those people who are exploited. And I think we'll take our final question now in relation to bail. Could we speak more about the granting of bail to primary carers? Are children's interests considered here? There's a proposed amendment, and we have talked about that, to the bill to be debated next week. Well, I'm being told here early December, which aims to introduce new laws on granting bail to primary carers. Yes, we have talked about that. We're both have very vested interests in that legislation getting over the line. We think the Lords are wrong to reject it. We're hoping it's going to make its way through. It's, I think, at the report stage now. And essentially that's been the core of what we've said today, is that Shona's research shows that judges are not taking into account the best interests of the children at sentence, and there needs to be a statutory duty to do that, to comply with our commitments to the Convention of the Rights of the Child and not to discriminate against those children. So that's everything that Shona's told us today. Both anecdotally and through research, we can say that judges are not getting it, as the Lords have suggested, or Lord Wolfe has suggested. So really important to follow that debate, and if you have any access to those people who are likely to be voting, express your views. Meanwhile, bail, Shona, what do we have to say about bail?
So I think it is absolutely necessary that that there is something that says at bail that they must think about primary caring responsibilities in children, because at the moment there isn't anything that is, again, compelling anybody to do that. And there was a case a couple of years ago, I wrote a blog post on it, I remember the name of it, where halfway through a trial, the judge revoked bail for the mother, and she was the mother of a baby and a 13 or 14-year-old, and the child, the 14-year-old, was in court and heard the judge saying, right, you're not being kept in custody, you're not going home for whatever reason. The child started to cry and speak out, I think, because suddenly they were going to be home alone and they didn't know. And what happened to them was the judge pulled them up the next morning and said, you are going to be going to prison as well if you make any more noise, and I will hold you in contempt of court. Rather than having thought of this child, and it was then an appeal, so there was an appeal from sentence because of the way the proceedings had been handled, and the Court of Appeal said it was wrong to revoke bail partway through, and it was wrong to say to the child. There was not a mention from the Court of Appeal about the fact that actually the judge was wrong to have not inquired as to what would happen to the baby and the child when the mother stayed in prison that night. So we are long overdue something really specific on bail. It's very important, and that is such a quick decision that affects children. You know, there's perhaps been a trial, there's maybe been a bit more warning. A bail hearing, that's pretty instantaneous and very quick, and people have not had time to put things in place, and often will end up with somebody later getting bail. I mean, the terrible case of the woman whose baby died in prison, and she'd been remanded to custody, and actually then whenever there was another hearing she was given bail, but in the period where she had been remanded, that was when she gave birth to her child. So I absolutely think that we need it, and at the moment no children's interests, despite what we might be told, I do not think are routinely considered in bail hearings.
Thank you. I think what we've seen there is we had a window into the statistics of the appeal court understanding the best interests of the child and having given all these decisions that show it should be taken into account, but still not saying what needs to be said, which is you must take into account the best interests of the child. And if that hasn't happened, certainly over the quarter of a century that I've been practicing and you've been practicing and researching, then there's an obvious need for a statutory duty. We have got other questions about mental illness and trauma suffered by women. I think it's really interesting to read some of the UN stuff, the Tokyo rules and the Bangkok rules, that just tell you globally about the vulnerability of women in prison. There's plenty of research out there on vulnerability of women in the criminal justice system. Most of all, I'd like to recommend Shona's book, which Maternal Sentencing and the Rights of the Child, published by Shona?
Palgrave.
Hargrave, thank you. Sorry.
Palgrave.
Palgrave, sorry.
Yep,
got it. So I think take that with you and make the judges read it. Is probably the best medicine that we've got at the moment, or take it to the Lord that you know that's going to vote next week. Thank you so much, everyone, for coming. Shona, thank you so much for sharing your expertise. Just to remind everyone that what we try and do is follow up these lectures with an article in our Libertas newsletter. Don't put us under too much pressure. We will get to it at some point, so that some of what we've said today will be set out in an article. So if you weren't here at the beginning, that will be available to you. We will also share the video of this webinar on our YouTube channel. So I hope it's been useful for everyone. Stop and think about the exceptional nature of your case if you're representing a primary carer, particularly a mother, and those terrible statistics that we heard from Shona, and the terrible result of your research, Shona. I hate to say it, but to have that window into the judicial mindset is such a shocker, that it really does demonstrate why we need that statutory duty, that no-brainer of a statutory duty to take the best interests of the child into account at the point of sentence. So Shona, thank you again for sharing your expertise. I think we've gone slightly over time, but it was so worth listening to. And we look forward to more research that you're going to do in your postdoctorate fellowship. Thank you very much, everyone. Bye-bye.